Good morning.
Good morning, Your Honors. I'd like to reserve 3 minutes for rebuttal.
3 minutes, certainly.
May it please the Court, my name is Jeffrey Payne of the Rutherford County Bar, and I represent the appellant, Donna Horton Howell. We respectfully ask this Court to reverse the trial court's modification of custody, designating father as the primary residential parent, or at a minimum, to remand this matter for application of the correct legal standard and entry of findings sufficient to support such a change. At the outset, I want to be clear about what this case is not. This is not a case where a child was unsafe, neglected, or unstable. This is not a case where a child was failing academically. This is not a case where either parent was found to be unfit. This is a case where both parents were found to be good, loving, and capable parents, where a child had thrived for years under an existing parenting plan, and yet the trial court nevertheless changed the designation of primary residential parent without making the threshold findings Tennessee law requires. The parties in this case are the parents of a single child born in 2016. From birth through the entry of the prior permanent parenting plan that was entered in 2019, mother served as the child's primary caregiver. In 2019, the parties entered into an agreed parenting plan that designated mother as the primary residential parent and provided for shared parenting time and reflected a compromise reached after some contested litigation. That plan was not provisional, it was not experimental, it was intended to bring stability to these parents and this child, and it did do that. For roughly 5 years, that plan governed this child's life.
During that, in figuring out whether, and talk about stability during this time period, and figuring out what exactly the material change of circumstances are that we're supposed to look at, I want to get a clear sense of what's fair game for consideration, right? Because there's a number of things referenced in the best interest analysis, and I'm not sure whether they're fair game or not for the material change of circumstances analysis. So in looking at the order, the court says, in terms of identifying, makes a finding of fact the following constitute material changes of circumstance. Each of these individuals, since the adoption of the parenting plan, is married, they're additional adults, step-parents in the home, they're multiple step and or half children in the home, and both parties have moved residence. In considering whether the trial judge erred with regard to the material change of circumstance, is that where we're limited? Are those two, those are the material change of circumstances, and if that's enough, then it's enough, and if it's not enough, then it's not sufficient? Or can we venture into the best interest analysis and considering whether a material change of circumstances occurred here?
Sure, and I understand the significance of your question, because without that threshold analysis of the material change in circumstances, the heightened threshold analysis, this being a change of PRP designation, the court never should have conducted a best interest analysis, but it did. So the question is whether or not you should consider those. And our position would be that even if you did, it still doesn't rise to the heightened standard.
Well, before we get to the even if, okay, should we? I mean, this is, trial judges, the courts speak through their written orders.
Sure.
This is what the trial judge has said the material changes of circumstances are. Is this court free to go through the best interest analysis and say, well, maybe this is insufficient, but I can see something in there that might have been, which the trial judge didn't say was a material change of circumstances, but maybe that actually does constitute a material change of circumstances. Is that fair game, or are we confined to the order that says, here's what I found them to be? Sure,
and I appreciate the distinction between the even if and the, well, what if they did, but and I assure you, when I was researching this case, I was looking for a silver bullet along those lines. If I could have found a case to draw, that explicitly said you're supposed to stop and not even look at this other stuff that the court said.
Is there anything that goes the other? Did you come across anything that goes the other way?
No, neither way.
Okay, so you would view this as an unsettled question.
Certainly, and I would, to give, I would certainly prefer that the court didn't look at that best interest analysis, because, some of it helps us, some of it hurts us, but the two factors that the court did explicitly consider, those factors would certainly give us a win. The best interest analysis sort of muddies the water up a bit. But, you know, to give you a fair assessment of my understanding of the law and sort of the sense I get, I would tend to think that, you know, the courts of appeal are meant to review trial court orders in their completeness. You know, even if something's out of order or the factors weren't, you know, gone through with exacting detail, it's the cumulative, you know, overall findings in the court's order could still be considered. So I would say that my inclination from my reading over the law over the decade or so I've been doing so would tend to indicate that this court could probably consider the entirety of the order. But like I said, even if we did get there and look at everything, I don't think it reaches to that heightened standard.
If we're doing that, why isn't the educational piece sufficient here to constitute a material change of circumstance in terms of if this is fair game to get into the factors of analysis here? And the trial judge is saying that the kid we've got this dispute about education, mom is put the kid in essentially a homeschool program, online education, and the trial judge clearly had concerns about that education. Why isn't that enough to constitute a material change? I mean, it's not one of the ones identified here,
Sure.
But why isn't that enough to constitute a material change?
Well, there's a few things about that one in particular. Number one, you know, a father had been aware of this change in the child's school for over a year before he ever brought suit. So that sort of undermines the credibility of, you know, this child had already been enrolled, had already been showing that he's successful in that.
Well, but isn't the child starting to struggle in the program too? I mean, the child in the first year, and mother's testimony, if I recall correctly, is 99s and 100s. And then in the second year, child seemed to be struggling. And the trial court also had concerns about lack of interaction, that the kid was instead of, you're participating in school on a screen, right? As opposed to being in a classroom with other students. And this is not a 17-year-old child we're talking about here. So, and part of that, and you say, well, you know, you waited a year. Concerns also, some of the problems here also started to develop in that later time period too.
So to address the first part of your question, really the only blemish that anyone ever brought up in this entire case that would ever show that there was ever any single thing that might be a negative, that you could construe a negative inference from as far as this child's life, is he got a C on a math test. And that's really what happened. This trial occurred in late January of last year.
What about the trial court's concern, though, about interaction? I mean, this is a child that, 8 years old at the time, if I remember correctly here, who's not in a classroom. And the trial judge also found that the school quality was significantly higher at I mean, you know, whether that evidence should have been in or not. But the trial judge made that determination. There was no objection. And so, you know, we have a school that the trial judge is concerned about the quality of. We have a lack of interaction in terms of a day-to-day basis for a child who's, you know, a young child still. And is that not enough here to constitute a material change of circumstance where there's a harm? I mean, one of the points you make in your brief, right, is there's a failure to connect the material change of circumstances with actual harm to the child.
Sure.
But putting aside the C issue, and I understand mother's testimony, it's one test, and that's why the grade looked lower, and there was a lot of points, opportunity to make up. I got all that. But in terms of the sort of emotional, social aspect of schooling too, the trial judge also had some concerns there.
So to deal with the one part of the question where you discussed the quality of the schools, there was some discussion at trial. You know, they had these scores. Father testified multiple times about school rating scores, but none of these scores are in the record. We don't know where they came from, where they're sourced from. By all accounts, the home school that the child was enrolled in was a good school. It had good administrators. It had good.
Did father not testify as to the rating scores on the schools? That's not in the record.
No, I'm saying he did testify.
Oh,
about
okay, he
that,
did
but
testify.
There was no exhibit entered.
Okay.
There was no, he never testified about the source of these scores. He just testified this school got a
Was there any
7
objection?
and this got a 6.
Was there any objection raised to his testimony?
I don't believe there was a concurrent objection, no. But at the same time, I don't believe that father developed a sufficient record to show that there were any problems with these schools. It was just some arbitrary scores that, you know, he might have found on some paid website I mean, we have no idea where he got these scores from, whether they're publicly available or if it's, or what it is really. So yeah, as far as the quality of the schools, I believe that the school the child was enrolled in was a good quality school. There was really no substantive proof that, and the reason the child was enrolled in this school was because that the mother was trying to get the child into a better school. The one that the child was designated zoned for had poor scores according to the mother. So it's not like it was a decision made by the mother to try to advance the best interest of the child. And as far as interaction goes, there's a lot of testimony from mother and no counter testimony from father. I mean, father supported everything mother said about the child's interaction. You know, mother said she takes him to the Urbanator to where he can play and interact with other kids. There's also these other play dates. He does sports and extracurriculars through, you know, even though he's homeschooled, he's still allowed to do these things through the schools that he's zoned for. So mother was really adamant about that in her testimony, that this child is excelling in all aspects, emotionally, socially, academically, and that he's living a fulfilled life and enjoying, you know, his time with both parents, and that there really wasn't any, you know, that third factor that you mentioned is you have to show that the child's well-being was affected in a meaningful way, and that's just not here on this record. There is no evidence that this child was subject to any harm or distress or anything like that. He made a C on a math test at the beginning of the semester, and he still had months to bring that grade back up. Prior to that, he had 99s and 100s was the testimony, the uncontradicted testimony. So he was doing good. He made 1 C, and we end up flipping our PRP designation. And it's our position that deserves reversal.
Thank you, Mr. Payne. We'll hear from you on rebuttal. Mr. Lassiter. Good morning.
Good morning, Your Honors. I'm Seth Lassiter of the Murray County Bar. I represent Alex Williams, the appellee, and he's present in the courtroom today. Judge Usman, if I could speak to Your Honor's questions. We would submit that the education decision-making authority violation is alone sufficient to constitute a material change.
I want to take you back to that very first question then. So the trial judge's order, and read them to opposing counsel here, and in each of these individuals, since the adoption of the parenting plan, is married, they're additional adults, step-parents in the home, they're multiple step and or have children in the home, and both parties have moved residences. Candidly, just looking at that in and of itself, that doesn't look like enough to show material change of circumstances, just that statement alone here. And in thinking about these factors, let's take step-parents, for example. The more specific findings by the trial court seem to say that that's not really a meaningful impact on the child's life. There's certainly no facts that connect it to any kind of adverse harm. And that goes both ways here, right? And the trial judge didn't seem to think there was anything about stepdad or stepmom that was problematic. So are we limited, in considering material change of circumstance in question, do we look at these two, the trial judge said, these are the ones I'm saying where there's a material change of circumstances, or do we dip into the best interest analysis and say, well, these two aren't enough, but boy, that educational one, I could see how that's a material change of circumstance. What's your understanding of Tennessee case law on that question?
Thank you, Your Honor. First of all, I'd point the court's attention to page 150 of the technical record. That is the trial court's order. At the bottom of page 2 of that order, The very last sentence is, the court will make additional findings of fact relative to all of the foregoing being the material changes. And so, to Your Honor's question, I don't believe we're limited in just those two things because the court clearly made findings of fact.
With regard to these two, though, so can we break out educational as a separate category? Because just being candid in terms of thinking about relocation. With regard to step-parents, I'm not sure what additional facts show there's a material change of circumstance with regard to step-parent, because the trial judge's additional facts seem to be, I don't really know much about stepdad, I don't know much about stepmom, I don't really have any much of a concern with either one of them. That seems like a hard road to get to material change of circumstance when that's your additional further finding on that point. With regard to moving residences, and the trial judge is concerned that mom may move again at some point, and mom and dad both move, but we have Tennessee case law that says moving alone is something that's anticipated, that alone's not enough. So, and can we look at a third that's not listed by the trial judge, or are we confined with those additional findings? I take your point, very fair point with regard to additional findings as to those two, but can we look at a third category, or are we limited to those two categories, let's say?
Judge, I think I might read that sentence differently than the court might be reading it. I read when the trial judge says the court will make additional findings of fact relative to all of the foregoing, I read that to mean relative to whether there are additional material changes. So because the court did not list those additional material changes in that first paragraph doesn't mean we have to ignore when clearly in the best interest analysis the court made findings of fact that do amount to material change. Per se under the statute, a violation of the joint decision making with respect to education is per se a violation of the heightened standard under the statute. And so just because the court didn't say, I'm putting it in this section of the order, doesn't mean we should ignore it, that it is plainly a finding of fact that there has been a substantial material change in circumstances. And we focused on education, Judge, but I would also say the same analysis applies to the counseling, non-emergency health decisions. And to the extent there was conflicting testimony, I would point out that the trial court made a determination that the father was credible and the mother was not, and conflicting testimony is weighed in favor of the father.
What is the counseling violation? So there's a domestic violence incident, pre-stepdad incident, right, that the child has some counseling with, and the trial judge was very supportive of that. What ended up being the further counseling? Was it just a conversation about whether the child should have counseling, or was there actual further counseling that occurred?
So, to the extent there's confusion on the issue, perhaps that's due to my briefing, and I apologize if that's the case, but sort of two separate issues. In 2020, if memory serves, there was a violent assault. The child was present for that assault, and the parties conferred and agreed the child would receive some counseling of some kind.
And everybody was on board with that, and the trial judge was quite happy with both parents with regard to that.
And I think I can represent to the court that it was minimal. So what was it, one time or two times or three? I'm not really sure, but it didn't go beyond that. But then when we fast forward to 2024, separate issue. The mother says, well, the child knew that his step-siblings or half-siblings or whoever were in counseling, and he wanted to go to counseling. And the father said, well, that's not necessary. There's been no trauma. There's been no need. I don't think he should do that. Well, the mother took him anyway. Plainly, we believe that's a violation of the permanent parenting plan from 2019 that required the parties to share non-emergency health decisions. The court found so. The court made a finding that the mother violated the plan when she took the child to counseling in 2024 over objection of the father. So that's yet another instance, we believe, pursuant to the statute, per se meets the heightened standard of material change. Now, the fact that that's not listed on page 2 of the court's order under paragraph 4, this is a material change, I don't think means we should ignore that. Because, again, it's plainly a finding of fact that the parenting plan was violated, the mother violated it. In fact, I think the court said she showed no interest in working with the father on these things. She unilaterally made these decisions in contravention of the plan, in violation of the plan, thus in violation of the statute, and that is per se a heightened material change in circumstances. So again, going back to the original discussion, the court will make additional findings of fact relative to the foregoing. I don't read that to say relative to those two grounds. or let's say relative to the court's finding of additional material change factors.
With regard to relocation here, the trial court's concern was stability-based, as I understood it.
I agree with Your Honor.
That strikes me as a little odd, given that we're starting at a default point of we're going to maintain the current primary parent because of the value of stability. And here the trial judge saying, well, relocation poses a threat to stability, so I'm going to unsettle the current plan. And how, it doesn't seem like there's any weighing of the giving weight of the existing stability of the current parenting plan by the trial judge in analyzing that factor. Did the trial judge need to give some degree of weight to that in considering, when you start considering stability, and stability as a default is built into the current plan stays as the default, you got to move from it, right? You have to have that threshold showing, and then you have to show best interest. Is that an error by the trial judge in not affording more weight to the value of stability of the current plan?
I don't think so, Your Honor, because the trial court did contrast the father's relocation and the mother's. The father essentially sold a home that he owned, and before he could purchase a replacement home, there was, memory serves, about a 90-day gap where he rented a home. Those were his moves. Contrast that with the mother, who moved from Murray County to Clarksville, proposed a relocation to Mississippi that didn't happen, back to Murray County, perhaps Williamson County. And then additionally, I think the context is important that this case began with mother's proposed relocation to Washington State. So as it existed up until about a week prior to trial, the stability, quote unquote, and the continuity of care in the mother's home was to relocate to Washington State, which of course is a vast change in the child's stability. So the court did contrast the two parties in that regard, and I think that context of, we're not talking about stability of moving within this neighborhood or to the next town over, which Mr. Williams' moves were. They were all within less than 15 miles, I believe, all within the same community essentially. So I think the court, in other words, I think the court did weigh those things in determining that the relocation of the parties was in fact a substantial material change and that it had a negative effect on the minor child. So again, Your Honor, I think the court is not bound by the two explicit findings. I think this court can tell that the trial court made additional findings of fact, that there were substantial material changes in circumstances. Those are the marriages and the moves that are explicit. The trial court found that the mother does not facilitate and encourage a relationship with the child. That was a plain finding of fact that the trial court made. That would be additionally substantial material change in circumstances. The mother lacked credibility. That was a theme throughout our one-day trial and throughout this litigation going back. We've discussed at length the mother's violation of the plan relative to joint education decision-making and relative to non-emergency health. I would submit those are additional findings of fact as to material change. Because those are findings of fact, the trial court is owed a presumption of correctness on those. And I would submit that that is where we find the court's analysis on material change in circumstances. And if the court has any additional questions, I'm happy to address those.
Hearing none, thank you.
Thank you, Your Honor.
Thank you, Mr. Lassiter. Mr. Payne, your rebuttal.
So I just wanted to address a few things that were discussed just now. One of them has to do with the counseling. Mother's testimony was that she had other children who were engaged in counseling when the subject minor child in this case was in her care and custody. Everybody went with her to the other child's counseling, and the child had requested to speak to somebody, and the mother talked to a counselor about the potential for counseling with the child in the room. The counselor never talked to the child. Counseling never actually took place.
And that was the extent of the 2024 counseling.
Exactly.
And the 2020, the trial court essentially gave thumbs up to both mom and dad in terms of the handling of that.
Right.
Counsel. Okay.
Right. One of the best interest factors that my opponent brought up was that the mother did not facilitate the relationship between the father and child. And I believe, I didn't really address that in briefing very much because it seems ludicrous on its face. I mean, once you actually look at the filings in this case, the majority of what the court based that on was the mother's proposed parenting plan. That the mother had asked for a reduction in father's parenting time based on the 50-50 split they had before. When actuality, father, even by his own testimony, was not exercising nearly the full 50% of the time that he had been allotted. He was exercising much less than that.
Well, we have a conflict, though, in the original plan, right? I mean, the day total doesn't match the allocation of days. And so we've got that. It's not actually the, 182 and a half, 182 and a half. It was more, I guess there's some disagreement, right, whether it was 140 or 115. But father was exercising the day count distribution, right? It wasn't matching the 182.5, but it was matching the, like, this week, that week, it's like 3 weekends a month, and father was doing that, right?
Sure, the testimony differed on that. Mother testified that he was exercising less than the actual day count, and he testified that he was exercising more. But
didn't the trial judge make a finding, though, that essentially that any variances on that were essentially normal life variances of there's a particular day where the child would stay longer because something was going on, rather than any kind of major variation from the plan? Or am I misreading the order?
Well, no, I think it was a pretty major variation because, I believe it was 182 and a half both ways, but the trial court, I believe, counted it at 125 was the actual day count. So it was a pretty, what the actual day count from the substance of the parenting plan read was actually quite a bit different than
but not from the week breakdown, right? The 3 weekends, the alternate weekend, that part the parties were pretty closely following, right? It's the 182 and 5 which didn't match that didn't match the days. That's where the variance was. Okay.
Right. And so the court makes this argument that mother did not facilitate this relationship when in because she proposed this parenting plan that further reduced father's parenting time, but when actuality both parents were trying to reduce each other's parenting time. So it seems inequitable for the court to count that against one party and not count it against the other.
All right. Thank
And just to sum up, I just briefly want to state that the thing that we're focused on here, our main point is there is no finding that any of the changes that the court points out in this order ever affected this child's well-being in any meaningful way. And I believe that's the crux of this case, and based on that, we would ask for reversal.
Thank you. Thank you, Mr. Payne and Mr. Lassiter, for your arguments. We'll take your case under advisement.
Thank you, Your Honor. Thank you.
Call the next case, please.
In re Estate of Ronald C. Perry.